Welcome to Mediation 360, mediation preparation from the defense, plaintiff, and mediator perspective. My name is Mike Douglas, and I'm a partner at Parker Shaffie in Los Angeles. My practice is focused on representing plaintiffs in legal and accounting malpractice cases. I'm chair of the Beverly Hills Bar Association's Ethics and Legal Malpractice Law section, and I'll be moderating today's program. Joining us today and leading the program are Peter Thompson, Joshua Furman, and David Samani. Peter Thompson is a mediator with Judicate West. He brings over 30 years of experience litigating and resolving attorney liability cases for both plaintiffs and defense, with extensive trial experience in legal malpractice matters across federal and state courts nationwide. He has advised law firms on ethics and has testified as a legal expert in over 100 cases addressing standards of practice, conflicts of interest, and attorney ethics. Peter is currently dedicated to resolving attorney-related claims, including negligence and breach of fiduciary duty, through mediation, and he's also experienced in law partnership dissolutions and attorney-client fee disputes. He has taught extensively in the area of attorney responsibility and has served on the San Diego County Bar Association Fee Arbitration Committee. David Samani is a partner in the Los Angeles office of Louis Brisbois, where he chairs the legal malpractice defense practice. He focuses on defending attorneys against claims of legal malpractice, malicious prosecution, and breach of fiduciary duty across a broad range of practice areas, including transactional, litigation, and regulatory matters. David is a co-author of the California Legal Malpractice and Malicious Prosecution Liability Handbook, publication, I might add, I have on my bookcase, and it's an excellent product. Last and not least, Joshua Furman is a sole practitioner in Encino, focusing on client-side representation in attorney-client disputes. Joshua is a certified specialist in legal malpractice law, certified by the California Board of Legal Specialization, and he currently serves as the vice chair of the LA County Bar Association Professional Responsibility and Ethics Committee. When he's not practicing law, Josh enjoys officiating flat track roller derby, particularly when his kid is playing, and he's also a contest-winning fine scale model maker. So with that said, we're going to start our presentation, and we will hold all questions until the end. I like to think of this presentation as giving plaintiffs an opportunity to see things from the defense side in the course of mediation, and the reverse for defense interests. And then Peter's going to give us some insights into something that we all are probably very curious about, and that's what's going on behind the scenes with the mediator as we are trying to get cases resolved. So I'm looking forward to a really informative panel. With that being said, I think we're going to start off with Josh. You want to start, Josh?
Thanks a lot, Michael. I'm Joshua Furman, sole practitioner in Encino, and I do a lot of plaintiff side legal malpractice. I'm going to talk about some of the things that I think about when approaching mediation and settlement, and some of the best practices that we've learned along the way. Not in any small fashion, mediating with Peter, who's an excellent mediator, and of course, having David on the other side of some of those cases as well. Hopefully, if you've done any level of mediation, most likely this is not going to be entirely new knowledge, but hopefully this will be a little organized, a way of thinking about steps that we can take to get a successful mediation, even if it doesn't settle, and maybe pick up something new along the way. So, of course, if we go to the next slide, the guiding star of all plaintiff work really is client communication. And this starts at the very beginning of the case, but during the mediation process, when you're getting ready to mediate and when you're deciding that it's time to mediate, it's very important. Even when you're selecting the mediator, you have to talk to your client, understand their level of sophistication, and understand the extent to which they need to be involved in that process. Some clients have never been involved in litigation before, and some clients know half the mediators on a particular panel. You just have to make sure that you understand what your client's experience has been and what kind of inputs they may expect to bring to that situation. The best way to do that is simply talking with them and explaining where you are in the process and what steps you're taking along the way. Throughout this entire process, the duty of the attorney is, of course, advise the client. We're not necessarily making decisions for them. Sometimes we're the only ones that have that expertise. We need to be making those decisions. But the idea is that we're telling the client about those decisions, why we're making those decisions. And if they want to make a different decision, trying to understand why and advising them about that decision. So through that initial process of getting ready to mediate, we're going to talk to the client about the process for selecting a mediator. That's someone that we pick usually. The cost of mediation, this can be very important on the client side. All the costs, of course, are very important, but mediation cost can be one of the bigger costs you have before you start getting into experts and a lot of depositions and that sort of thing, depending on where you are in the process. So it's important that the client understands that you do have to pay for this, that it could be a significant investment, and you may want to consider whether or not, given a particular client or case, simply advancing those costs is the best course of action, or depending on what kind of arrangement you have with your client, you may just have them pay for it. But a lot of you that might be on straight contingency are just going to have to be paying for that. Of course, it comes out of the client's end ultimately when you get a recovery. So client consent on cost is still important. You talk about dates. Client has to understand that they need to be there. Understand your client's availability. Understand that, make sure that the client knows that this could be an all-day affair. They may not think that off the top of the process. You need to let them know. And all these conversations should be tailored around the idea of preparing the client for the process. Mediation mindset is a bit different than litigation when you're going to court and you're fighting all the time. Now we're going to change our gear a little bit and start thinking about the idea of compromise, the idea of potentially having to walk away from a situation with a less than satisfactory feeling. So we need to talk to the client, meet them where they are in terms of that mindset, and try and get them in a position where they're willing to be open to the process and not going to be put off by that initial low ball that the defense lawyer is probably going to give you, and the dance that you go through throughout the course of the mediation. And last, in 2019, of course, we have the new statute that came into effect, Evidence Code 1129, and that's a form that you're supposed to have your client sign as soon as it becomes apparent that you're going to go to mediation. It's got a disclosure in it. It explains things to the client about the mediation process and the confidentiality and the privilege that attaches to that process. You may not remember that you have to get that signed. And I haven't seen anything as far as cases having to do with what happens if you don't get it signed and issues that come up there. But that is a requirement as of 2019 to have that form provided in Evidence Code 1129 signed. The next slide. So as you are getting ready for the mediation, and even before you're getting ready for the mediation, there's a way of looking at the entire litigation process that at least has one track towards potential settlement. And that begins at the time of pleading. Of course, when you're pleading, you have to worry about getting past demurs. You have to worry about making sure you've got accurate information. You've prepared for the first few steps of pleading challenges or whatever may happen at the beginning. But pleading is also part of the settlement process. The insurance carrier is going to set a reserve for your case at some point. Usually it's somewhat early on. They'll do an initial. And it's in your interest to have that be as much as possible in order to ultimately effectuate a settlement. So, the amount of damages that you're pleading, the credibility of that pleading, that all starts at the very beginning when your case is being evaluated by the defense side. And of course, discovery then plays an even more important role. We're going to get some cases we're getting hundreds of interrogatories, all these document production requests from the defense side. And, yes, perhaps they're papering. Yes, perhaps we could call that churning even. Not throwing no shade on the defense bar, but we sometimes see some voluminous, questionable items. But the more we can provide in those responses is thinking about that as educating the insurance carrier. The carrier needs to know why they should be writing you the check. You can explain that to the client. Look, we need to tell them and be as forthright and clear as possible as on the facts that are good for us, on the documentation that we have of the issues, on the damages that we have. Let's put that out there. Let's not try and be too cagey about it. Of course, you need to plan about that, perhaps leaving avenues open if you need to in the future, particularly if there's developing issues. But educating the insurance carrier on what they're going to have to do in order to settle this case as early and often as possible is an approach to think about as you're going through the pretrial process. Then again, once you are starting to prepare for the mediation itself, is this tenderization process. Talking to the client about the issues that come up in a mediation, talking about what a compromise actually looks like, giving something away to get to yes, and then the risks of not settling, the costs that are involved. Sometimes a war story about, we did everything right and still the jury went sideways or the judge made the screwball ruling or whatever it is. There's always a story or two like that, just so they understand anything can happen at trial. You could have the best case, you could have the best lawyer, and you still have some risk, at least going into trial. And of course, if you don't settle, and you still have a lot of pretrial to go, or even just trial to go, there's money that's going to come out, and it's ultimately the client's money, whether it's court reporter fees, which can be very, very high now for trial, whether it's other discovery costs, depositions, subpoenas. In our line of work, dealing a lot with legal malpractice, we've got the expert costs, which can be very substantial. So that's something else that cost risks should be explained as part of this tenderization process. And then talk to the client about how you came up with the damages number. Obviously, most of that stuff is going to come from the client, but you're filtering it through. You're understanding what is legally cognizable, what is not legally cognizable, what arguments can you make credibly. And you're going to take those numbers and put them into your damage calculation and then sit down and tell the client, look, here's what's recoverable in your case. This stuff over here might not be recoverable. We've got better chance of this. We have a worse chance of this. Put together your best numbers that you can as you're getting ready for mediation, but be sanguine with the client about what's actually reasonable. And then when you're thinking about how to talk to the client about those numbers, I try and back into it by building the biggest damage number I can, and then say, okay, this number over here is a little less likely. Let's take a discount on that. The chances that we get to a ultimate, best day in court, are 60%. And we just sort of find those ways of discounting to figure out what might be a reasonable settlement value. In the abstract, I'll even look at something in the range of 40 to 60% of a best day in court as a reasonable settlement value to try and target discussions. And tenderizing the client to what that number looks like early can lead to a settlement if it's warranted. Don't sell your client short. But when you're trying to figure out how you're going to get a compromise out of it, and settlement seems to be the right way to go, these are strategies to consider. Again, this is all part of the communication process. As you get ready for the next step, make sure that you have enough information from the client to be able to prepare a good mediation brief. And lastly, as you're going through this process, think about if you have issues with multiple clients. This is something as we're preparing for this presentation that came up in our conversation, particularly, Peter was expressing some concerns about this. We walk into a mediation and suddenly it's chaos in one room because there's all these different ideas and different needs and different wants. Obviously, if you've got a conflict situation, hopefully you've already dealt with that. That's something you can't really walk into a mediation with. And maybe a conflict situation arises in the mediation and you've got your duties that you have to adhere to in that situation. But usually you'll be in a situation where you don't have an actual conflict. You simply need to have an understanding of what's going to happen with the money, should you get a recovery, and what's going to happen with client authority to settle and how that's going to work. And ideally, the clients, if you have multiple clients, will have agreed amongst themselves prior to going into that process, how that's going to work, of course, with your guidance, if needed. We'll go to the next slide. The mediation brief. Don't underestimate this, what it means, how important it is. This is how you educate the mediator. Your goal is to get that mediator in that defense room advocating for your client and explaining why they need to write the big check. It could be very important from the fact standpoint for understanding the actual issues. That's usually where the rubber meets the road. Maybe a few critical exhibits that are very important, but you're trying to be succinct, you're trying to be precise. I prefer a clinical approach. I think explaining things from a sort of a neutral perspective can be engaging with the mediator and helps them understand why they should be advocating for you instead of sort of overblown rhetoric that you sometimes see. And as you're going through this process, exchanging briefs with the other side is usually considered more productive for ultimately being able to get to a resolution. But even if you can't, exchanging briefs with the other side is very helpful for just understanding where you need to go with that case. Think about it as additional discovery. If you have a really good point and you're not sure how that defense is going to argue against it, what facts or evidence they're going to bring on what maybe your smoking gun, make sure you emphasize that, because over the mediation process, you can hopefully pull that out. And at least if you don't settle, have some more information to help you with the case as you move forward. And if there are difficult issues, client credibility issues on either side, availability issues, consider whether you need to address that separately, what things need to be said only to the mediator, because you need to fuel that mediator with the things that they can use as leverage in that case for you. And all these things can be important. Even being aware and letting the mediator know you're aware of weaknesses can be important. It just helps with the advocacy process, not only as you're advocating for your client in the mediation, but as the mediator is trying to advocate for a settlement. And make sure you are being careful with your damages. Make sure your damages number is credible. Go back to your discovery responses. Make sure that is harmonized. Make sure that it makes sense with your legal theories, and put it out in plain numbers by category as succinctly as you can, and then make a demand. And at this point is when you're going to put, at least in most situations, that big number that you're able to come up with, your best day number, on a piece of paper, and then you can start your process from there. But obviously, you want to try and get your best number forward, and hopefully communicate that to the other side by exchanging briefs ahead of time, so that there's time for the insurance on the other side to be able to tenderize themselves to settling with you. Tell the mediator about any history of talks. Of course, it's important to understand those dynamics and what you know about the insurance on the other side. It could be that the other side hasn't disclosed something to the mediator that's important about insurance. It could be that you have a misunderstanding about the insurance, and you can get that corrected throughout at the mediation process, which is also obviously helpful, not just for settlement, but understanding the dynamics in the other side. And last slide. So at the mediation, should be unspoken, but be on time and look the part. One of the things that's going to help you get to a settlement, if that's appropriate in your case, is the client believing that you're there to advocate and that you've done that job, and that they've seen somebody fighting for them in that room. This isn't to say you need to be barking at the mediator, you're matching their tone, you're being professional, but at least look like the lawyer that your client wants to see. At least present yourself that way, and make sure the client feels the support. Be ready to talk about other things in the case that weren't in your brief, have additional exhibits at your fingertips. If you need to share them, it's very easy. When a lot of these mediations are online on Zoom, you can just pull it off your computer if you've got it ready, or bring your laptop with you to the session. During the initial merits discussion, the mediator is going to be talking to you about why the claims are bad, and they're going to be talking to the other side about why your claims pose tremendous risk. Make sure the client understands that, so that they aren't put off by the negativity they're getting from that mediator. Understand that's part of the process. And when you get to the monetary portion, things that are second nature for people who've mediated quite a bit or been involved in cases, make sure the client understands what is midpoint negotiation, what's a bracket, why are these different numbers going back and forth, and we're seemingly playing a game. That's going to be very frustrating for a less sophisticated plaintiff who doesn't do this all day. And you need to explain that along the way, what goals you are trying to achieve by putting different numbers forward. And take cues from the mediator in that process. Of course, use your own judgment. You might not have as good a mediator as Peter there. But assuming that you do, assuming that you've chosen this mediator from reason, think about what the mediator is saying, because what you really want to do is read between the lines to understand what's going on in that defense room. You're trying to get every last dollar that they can put on the table in that session. And the best way you can do that is understanding their psychology, understanding the different dynamics that are at play, and what hard limits they have over there. And that's really just what you're trying to probe throughout the day. And as part of that, consider your audience. Maybe a point or a certain discussion isn't the best thing for your client to hear. Maybe you need to have a separate call with the mediator, maybe just between counsel. Again, use your judgment along the way and your understanding of your client's sophistication and how they might respond to something. An issue that I see on occasion is giving advice outside of expertise that the lawyer has, particularly in the area of tax. If you've got a complex tax issue, that perhaps your damages come out of some sort of securities, some sort of other business entity or investment vehicle, maybe you need to have tax counsel on hand to discuss what a settlement might look like, or what the consequences of a settlement might be, or things that have to be in a settlement to accomplish those goals. Having tax counsel available to you in those kinds of situations is super important, or super helpful at least, and certainly avoids the problem of you kind of going outside your expertise. And last is to advise the client when the right offer is made. It's the client's decision to settle. Rule 1.2, professional conduct, says a lawyer shall abide by a client's decision whether to settle a matter. But you're the professional, and it's your job to tell the client, this is the offer that you should consider accepting. Now, you abide by their decision, of course, and if you think they're wrong, you're going to explain to them why they're wrong. But ultimately, if you're making an unequivocal recommendation at the right time, when your judgment says this is the right settlement, or this is as far as they should go, then you've performed your duty, and hopefully have a successful mediation that came out of that.
Thanks, Josh. And thanks, Mike, for that introduction. So when Josh and I are adversaries, we don't often agree on much, but I think you'll probably find that on the topic of how to plan and have an effective mediation in a lot of areas, our thought processes are aligned. And not only on the notion that Peter is an excellent mediator, who you'll be hearing from soon. So from the defense perspective, I think as Josh started with is where I would start too. It sort of begins with communication. We can go to the next slide. Communication with the client, from an outset as defense counsel, you want to start discussing with the client what the client's objectives are about the case. And to do that meaningfully and fruitfully, an attorney will want to, from an early stage, develop an assessment of the case, the merits, the potential exposure, but also from the defense perspective, the cost of litigation. Defense counsel, you can be dealing with a client that has any level of sophistication, ranging from an insurance carrier whose business is to evaluate risk and then to litigate and oversee litigation of cases, to an entity that also may have a lot of experience with litigation, or you may be representing an individual who doesn't have any sort of familiarity with the process. And so, from the outset, I think a lawyer on the defense side will want to discuss with them the lawyer's perception of the case, strengths, weaknesses, and particularly of importance is cost. The attorney's fees, budgeting can be very helpful at an early stage, so a client will understand, even if the client thinks that this is a case that they did nothing wrong, that it's going to be costly to defend potentially. And that's something that always should be communicated to the client so the client understands what an aggressive defense might entail, what it might look like to their bottom line. Oftentimes at the beginning of a case and maybe through the end, clients may be on the defense side. Clients may be, vociferously pushing for a defense, adamant that they want to try a case. And that's fine. Obviously, as Josh said, client's decision to settle is ultimately what's going to govern. But the client should know what the flip side of an aggressive defense posture might mean, because it can be very uncomfortable when at the end of the day, you've reached a point and the client's looking at a bill that they didn't anticipate was coming. Ultimately, these sort of things will evolve too over the course of a case. So it's important too to continue that dialogue. A client might start out adamant about wanting to defend the case, but as the case unfolds, things change, right? As bills mount, or just as more information is obtained, or even if litigation fatigue starts to set in, the client's position might change. So communication with the client early about their case, the lawyer's assessment, and the potential cost is really important to sort of set the groundwork for when you want to try to seek mediation as a potential way to resolve a case. In terms of the defense side too, I always like to look at cases at the beginning and try to discern whether I think this is a case for early resolution. Is it a case, cases that are candidates for early resolution, there can be varying reasons for that. Well, on the one hand, you may have a situation where it may be a case that looks meritless, but is it a type of case that you think the other side might be willing to settle for something that's within the realm of cost of defense? And in those cases, an early mediation might be helpful so you can use the money that would otherwise go towards resolving or defending the case towards a settlement. That'll also depend on the client's perspectives, whether they want to look at things economically or otherwise. Also, obviously, certain times you'll be looking at cases and you'll wonder whether additional discovery or investigation is going to be helpful to the defense point of view, or do you think you're going to uncover information that will aid the case in resolving, or it might be harmful? There are some cases that you see from the outset that plaintiff may not know all of what's lurking behind the curtain, and maybe an early resolution to pursue settlement might be in the client's interest for that reason. These are all things that are important to kind of identify and discuss with the client at early stages to the extent that it's possible. So the client understands those things and can take it into consideration when considering whether to mediate a case. So when you are also looking at setting a mediation, I think the next thing to consider too is what mediator are you going to go with? In my practice area, defending lawyers, there's a lot of different underlying subject areas that might be implicated. I like to think about, do cases involve specialized practice areas where a mediator who has a background, maybe if it's an underlying securities case, underlying bankruptcy case, do you want a mediator who's going to be able to bring a depth of knowledge to that subject area? Certain times and certain clients, may be more receptive to different types of neutrals. All mediators have their own styles for one thing, and backgrounds. In some cases, it may be helpful to have a retired judge be a mediator if you feel like the client needs to hear from somebody who's had that role and can bring that depth of knowledge and experience as a mediator. Other cases, having a private practitioner, someone who was a trial attorney, or understands the realities of private practice, that might be a helpful perspective to have and a helpful person facilitating settlement discussions. Party dynamics as well will come into my mind, at least in my process when I'm thinking about mediators. If I think there's a party who's being driven by emotion, whether it's on the plaintiff side or the defense side, I'll think about whether that can be something that a skilled mediator may be able to address, and whether that should be part of the thought process in selecting a mediator. Another consideration too, in terms of deciding when to mediate, that I'll often think about, and this dovetails with whether a case is a candidate for early resolution, will be the procedural posture of a case. Is it, oftentimes, if there's a potential dispositive motion, mediating while that motion is on file but hasn't been heard can be a successful tool for the defense. It creates some additional leverage points for a mediator to focus on, or sometimes perhaps, the trial date. Is this one where a trial date needs to be, looming to have an effective mediation? This is also something where the cost calculus comes into play too, because mediating under either of those circumstances entails incurring upfront costs for the defense that you could avoid if you settle the case. So again, dialogue with the client, understanding the client's objectives and desires, and making sure the client is sort of apprised of the various alternatives that exist, all important when sort of making the first and early initial steps towards mediation. So then when you're more ready to move forward towards actually mediating, it's important to proactively prepare, and preparation, in this context, takes on a number of meanings. The lawyer obviously needs to be prepared. The lawyer needs to understand the case and be able to advocate effectively and persuasively for the client. But really having a successful mediation will require that the clients be prepared as well. And there's multiple levels of to that as well. As Josh alluded to, from the plaintiff side, you'll want your clients and key decision makers ready to be able to meaningfully participate in mediation. So if it is a case where there's an insurance carrier involved, you'll want both the client and the carrier's representative to be adequately apprised of the risks of the case, the strengths, the weaknesses, the exposure, the attorney's assessment, the reasonable settlement value range that an attorney has believes applies to this particular case. And also, you want them to be prepared for the settlement process itself. So Josh mentioned the disclosures under Evidence Code 1129. That applies to, obviously, to any lawyer to the defense side. You'll want the client to understand what mediation confidentiality is, what to expect from the mediation. And then from the defense perspective too, you'll want to try to identify potential hurdles that might present themselves when you're in the mediation process, and deal with them in advance if possible. And this can range from all manner of things. In a case where an insurance carrier is involved, sometimes there might be insurance coverage issues. There may be a reservation of rights from the carrier. The client may have retained coverage counsel of their own. Oftentimes, if there's a serious coverage issue that's going to bear upon resolution, it's likely helpful to have coverage counsel for the client and the carrier involved in the process, potentially at the mediation themselves, but certainly aware and discussing the coverage issues in advance of the mediation, so that a game plan can be developed and an understanding reached, and you're not stuck at the mediation with these things coming to light and disputes arising. That's sort of a nightmare scenario that you want to avoid from the defense perspective. There could be other hurdles too. In my practice area, most insurance policies, almost everyone I've dealt with, for a lawyer, will have what's called a consent clause. So the client has to give consent before the carrier can offer money to settle a case. That's something that definitely needs to be discussed in advance, and presumably has been before a decision to mediate has been reached. But if there are consent issues, that needs to be discussed. The client certainly needs to understand that consent is necessary, and be ready to discuss and address that. Sometimes there may be things like cross claims where the defense counsel may not be handling the cross claim. Obviously, that will need to be taken into account in the early plan or the preparation process, so that the client knows that and is ready to negotiate or deal with the cross claim at the mediation. These are all things too that will work its way into the mediation brief too. As Josh said, crafting a brief, it's a really important part of the process. You want the mediator to know, it's your opportunity to educate the mediator, and you want to do it as concisely but clearly as possible in the brief you're preparing. This is an opportunity to expand on the defense's themes of the case and theory of the case, address the defense's strengths, but also, to the extent that it's possible in the brief. And I agree with Josh too. I would certainly recommend and usually advise exchanging briefs because I want the other side to see my position and I want to see the other side's position. Addressing both the strengths and, to the extent that you can do it in a document that you feel comfortable exchanging, the weaknesses, because you can anticipate that your worthy adversary on the other side is going to be raising those weaknesses, and this is your opportunity to confront them and let the other side know how you intend to confront them. There's obviously, in every case is different, and there's certainly going to be cases where there's information that you don't want the other side to see. That could be information that is harmful to the client that you don't want the other side to know about and you don't think they know about. Or frankly, it could be information that you think is really harmful to the other side, or information that you think that if you privately disclose it to the other side in the mediation conflict in context may be detrimental to settlement. Maybe it'll be something that'll inflame the other side. That oftentimes in those cases, I'll do sort of a confidential supplement that's for mediators' eyes only, so that can be taken care of, separately. But to me, the mediation process, in addition to trying to resolve a case and obtain a settlement, it's also an educational process, both for the lawyer and for the client. And so obtaining as much information as possible, I think, is critical. And that starts with being, open and using the process and mediation confidentiality to its full extent. All of these issues too, problems with coverage, problems with client consent, the sort of thorny issues, I think are helpful things to discuss in advance with the mediator if it's possible. I'm a big fan of pre-mediation calls. I think we'll talk more about that later, but all of this, I think is helpful to get out and address before you actually get there on the day, so you can set yourself up for hopefully as productive as a mediation as possible. And let's go to the day itself. So obviously at the mediation, your role is to be the client's advocate, and you want to be there and you want to advocate effectively. You also need to be advising the client appropriately. As Josh said, they need to understand the mediator's function. They need to be prepared and ready for the mediator to come in and lean hard on you and try to educate you about gaps in the defense or weaknesses that you may be aware of or maybe that you don't appreciate. And being able to understand and appreciate and educate the client about risk is a key part of the process always for a defense lawyer. Mediation can really be a valuable tool in issue spotting or getting a new perspective on aspects of the case that you may not have appreciated to that point. During the mediation process too, avoiding ambiguities, particularly in terms of settlement. When you're preparing for settlement, it's important to, again, sort of understand the client's desires in terms of what the settlement's going to look like, both from a monetary and non-monetary perspective. So if there are key non-monetary terms, confidentiality, non-disparagement, whatever that may be, that should be communicated explicitly during the mediation process, hopefully before. But when you're making settlement proposals and offers, it's important that the mediator knows what the client's expecting, so that you're not stuck in a situation where you think you've come to an agreement. You may have an agreement on a number, but the non-monetary terms then come to light and there's an issue and you're sort of back to square one, or at least back to not the final square. I personally, where possible, where you have a case that allows it, like to bring a proposed long form settlement agreement to the mediation. So my hope would be that we could, use the mediator potentially to hash out any disputes and come away with a signed settlement agreement when all is said and done there and then. So you don't have to worry about these things flaring up and becoming problems down the line or after you think you've had a deal. Always my nightmare to think you have a deal and then realize there's a problem. And I'll turn it over to Peter then.
Thanks, David. I will try not to repeat what David and Josh have said. I may want to emphasize a few areas and go a little deeper, but I do want Josh and David to jump in. Feel free to interrupt and add your perspective as I go through this. Initially, the pre-mediation conference, I think, is important because of the ability to let the mediator know about your case and about your clients. When you choose a mediator, you should choose somebody carefully. And I say that because sometimes people say, well, I let the other side choose a mediator and whoever it is okay with me. If they think that person's good, I'll be fine. I don't believe that's the right way to go about it. I think you need to carefully analyze the qualifications of the mediator and whether they are the right person for your case. You have to know your mediator. There are many mediators who, for example, have a limitation on the number of pages for a brief. Well, if you've got a very complex legal malpractice case arising out of a securities problem, and it's going to take 40 or 50 pages of brief to fully explain it, you don't want a mediator who's only going to accept 10 pages. You want somebody who is going to read all of the brief and maybe another 200, 300 pages of exhibits. On the other hand, if you have something that's a very straightforward case and you want it to be brief, maybe the person who accepts 10 pages is exactly what you want. Keep it simple. Another thing about briefs quickly is you have to submit them well in advance. Too often I get briefs a day before, 2 days before, and it's 30 pages, 40 pages, and I'm thinking, how am I going to get through this? And then remember any of it, and then be able to talk knowledgeably about the issues to both sides. You put the mediator in a really difficult spot. The earlier you submit the brief, the better chance you have that the mediator is going to be able to analyze what you're saying. And in conjunction with a pre-mediation conference, the mediator often will say, okay, I need this, I need that. Send me the case that supports this proposition. I don't understand your damage analysis. You may want to rethink how you set forth your damages. It could be a number of different things. But if you having that pre-mediation conference that takes place 2 days before the mediation, you will learn what the mediator is confused about. And if you can clear that up for them before the mediation itself, you will be in a far better position at the mediation because the mediator will be able to be your advocate in the other room as opposed to your critic. Now, I'm one of those mediators that's a little unusual. I tell both sides the same thing. I think it's super important that both sides understand my analysis of the case. And I'll start out the mediation by giving each side my analysis of the case based upon the conversations I may have had with the attorneys and the briefing and the documents themselves. I read every single page. Because I do legal malpractice mediations, The devil is in the details, so I have to become extremely familiar with the details. It is not uncommon for me to read entire depositions, entire lengthy agreements, multiple drafts of agreements to see how they progressed. All of those things are important because of the details. So the quicker you get your mediation brief into me in advance of the mediation, the better off you're going to be. And I think that's the case for 99% of the mediators. In terms of content of the brief, again, if you know your mediator, you can tailor the content. I can't tell you how many times I will get briefs that go on for 4 or 5 pages about the law, what the law is, and the standard of proof and the elements of proof for a legal malpractice case. Hey, you picked me because I've been doing this 40 years. Why do you need to tell me what the standards are? Get to the point. Make the brief shorter and emphasize the issues that are important in the case as opposed to educating me. Now, there may be a recent case that you want to point out. There may be a case in the past that is right on point and you want to point out the similarities. Fine. Understood. It never hurts to remind me. But to have the general elements of a legal malpractice case repeated over and over doesn't do you any good. I'm just going to skip over it anyway. It's really important to understand, and I think both Josh and David address this. If there's a key issue in the case that is potentially a problem for you, you need to address it. Now, whether you address it in the brief that you exchange with the other side or in a separate supplemental confidentiality, confidential brief only to me, no problem. But you have to address it. If you think the mediator is going to miss it and somehow not address it, well, think again, because the other side's going to address it. And the mediator, 9 times out of 10, is going to understand that there's a problem and start asking questions. That doesn't look good in front of you or your client. So, any problem areas, address them head on, even if it's confidential. Now, there may be issues that the other side would never know. Your client wants to retire. He wants this out of his life. He doesn't care what it settles for. He's never getting insurance again. Things like that, where the mediator needs to know, okay, the client is pushing for a settlement. So tell the mediator, okay, we need to get this case resolved, get this out of my client's life. Now, it may be that you tell me that the insurance company is not cooperating with that theory, that they want to save every penny possible. Okay, but tell me beforehand. It's not something I want to find out during the mediation. Again, the pre-mediation conference is a great place to do that. If you have a piece of evidence that, as I think both Josh and David alluded to, either helps you or hurts you, and you don't want to disclose it to the other side, but you do want to have it affect the way the mediation goes, tell me. I'm really good at compartmentalizing information. And I never, ever, ever would betray the trust of the lawyer who tells me you can't tell the other side this. They may not know about it. Now, if the other side brings it up, I'll go straight back to the lawyer and say, they already know. So don't worry about it at this point. Figure out a way to address it. Insurance information, again, addressed by Josh and David, very important to know. In the legal malpractice area, there's always issues of insurance, coverage, covered issues versus non-covered issues versus limits versus deductibles, self-insured retentions, reservation of rights letters. There's so many issues of insurance. If those issues are important to your case, bring them to my attention early because it will affect how the mediation goes. It is not uncommon for me to do pre-filing mediations, and the plaintiff side will say, we don't know anything about their insurance information. We've asked, but they haven't told us. I will always go to the defense and say, they want to know about the insurance information. How much, what's the deductible? Is it a burning limits policy? Those types of things, basic things. Is there a reservation of rights letter? Often the defense will say, we're not going to disclose that. My first question is always, can I tell the other side that any insurance issues, limits, problems won't affect the settlement of this case? If they say, yes, you can tell them that. I'll say, fine. You understand that, you need to be honest about it, but fine, I have no problem. And then you tell the other side that. If they say, well, I don't know, it could. My response is always, well, why don't you tell the other side? If you really think that you want to settle this case, the other side's not going to negotiate in the dark. And if I can't tell them that it's not an issue, they're going to become very suspicious as to why you're acting the way you're acting. Let's get it on the table. Figure it out. Next slide, please. Again, just to remind everybody, most mediators, if you ask in advance, say 2 weeks, 3 weeks, contact the mediator directly. If I send you a deposition and ask you to read it, will you read it? If I send you a 25-page brief, will you read it? Get to know your mediator. The next thing I would say is understand and be prepared to identify your non-negotiables. Now, Josh and David both alluded to this. The non-monetary terms of a mediated settlement are so important. Is this going to be a mutual general release? Is it going to be a mutual specific release? Is it going to be a 1542 waiver? What are the things that you want? Confidentiality, non-disparagement, enforceability under 664.6. All of these issues need to be addressed early in the mediation so that everybody understands before you get down to the last minute where you say, okay, we've got a deal. Now let's talk about the non-monetary terms. Well, all of a sudden you don't have a deal. If you get those non-negotiable, non-monetary terms out of the way early, you'll be surprised how much easier it is to come to reach a settlement. Next slide, please. I wanted to talk about success in a mediation. I think David addressed it, and Josh did as well. You can measure success in a mediation by whether you settle or not. That is one measure, of course. But in my opinion, you should also measure the success of a mediation by how much you've learned about the other side's case and how much you've learned about your own case. A good mediator is going to challenge you on the issues in your own case. He's going to analyze your case for you. He or she is going to analyze your case for you. And they're going to say, these damages don't make sense to me. And here's why. Or I understand your causation argument, but is that really causation? Is that really something that caused this damage, or is it a third party or a different issue or the economy or COVID, or is it something else? You're going to learn a great deal about the other side's case in a mediation, but I think even more importantly, you're going to learn about your own case and how to present it, what the problems are, and how you overcome them. And a good mediator is going to, again, challenge you to explain logically your case. Mike?
All right. Thank you, guys. Great presentation. We've only got about 5 minutes left. If anybody wants to toss out a question, please do so. We'll take a couple of minutes here. I have a question for the panel. I'm going to start with you, David. One of my favorite boxers, Mike Tyson, said, everybody has a plan going into the ring until they get hit in the mouth. And so I want to talk about what happens when your evaluation, your carefully crafted evaluation that you, David, have gotten authority from your claim adjuster in the insured cases. You, Josh, have properly conditioned your client, and you've got their expectations reined in. All of that work has been done, and then you show up at the mediation and your evaluation doesn't track with the mediator, Peter's evaluation of the case. And I've had that experience with Peter. How do you handle that pivot now that maybe the case as you've seen it isn't quite tracking with this third party neutral that you've hired to give you a new, fresh perspective? David, you want to start?
Sure. And I take it you want a better answer than just sit there and cry, because that might be my
if that's your approach.
Yeah, no, it certainly, one of the things that it's oftentimes useful in a way, like to learn, okay, this is a perspective of someone I really respect, or someone, a mediator who really knows their stuff that I haven't seen. So part of the dialogue I will have in that situation once the mediator's out of the room with the client is, well, this is one of the reasons that we hired this mediator. We put our trust in this mediator. He's bringing this new perspective, and let's talk about it. Let's consider it. From a practical perspective, it can often mean that this mediation is probably not going to result in a settlement, because if, to that point, you've evaluated and assessed the case a certain way, and the mediator says you got it all wrong, likely what that's going to mean is that you're going to, what I want to do is use the day to continue the dialogue, to continue gathering information and exploring the analysis, so I can then take all that in, probably, unless the carrier has brought way more money than I thought they were going to, or the client's willing to just settle it, but probably take all of that and reassess and say, okay, let's look at round two, right? Now that we've educated ourselves and we can digest it, and how does that change to how we were thinking about it? Let's go at it again. That's probably how that's going to play out, unless I'm on my best. I ate my Wheaties that morning and I can talk the mediator out of it.
Josh?
Well, Mike, if I could continue your boxing analogy a little bit, you got to roll with the punches. And part of the conditioning of a client when you're going in is to be flexible, to be ready to handle, with an open mind what's going on in that mediation. And I had an issue not too long ago. I think it was with Peter, maybe a year or so ago, where I had a legal issue that ended up being very significant for damages that we hadn't really considered, and the defense was all over it. And the first time I came was at the mediation. I fought back at first. If you think you've got some merit, feel free to push back in your professional way. But then I reached into the briefcase, if you will, and started really pulling out documents that I thought I could use to 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 uh, to reinforce a new set of trenches, if you will. So, okay, the line is moved. What do we have at this other space? And we're able to kind of rejigger on the spot and come up with a modified defense theory. But I think the direct answer to your question is it starts with that preparation process and being ready to move and making sure as you're going in, if you're really going to settle it, no one can be firmly entrenched in one position or another, and there has to be some willingness to move around.
We've got a question from Shelley O'Connor. I want to toss out. What is your approach to having your client speaking directly and responding to the mediator's questions? Why don't we start with you, Josh?
Yeah.
And David, I'd like to hear from you on that, Peter, and then we'll wrap up.
That's a strategic thing to think about. Sometimes the mediator wants to talk to your client directly and establish some rapport. And sometimes that's going to be a disaster. But there's a couple ways to think about it. One is to let the mediator see what you're dealing with, and some of the perhaps emotional barriers to settlement that are there, and that can help give the mediator an understanding what they need to do to get the deal done. But you don't want that to damage your credibility and your client's credibility at the same time, and the impression of what they might be like at the stand. So you kind of have to approach that strategically. I'd go back to the point about knowing your audience. Think about what you're projecting, how you're projecting it, and if you have to take your client aside and say, "Look, mediator, give us the room." Take your client aside and say, "Look, this part isn't helping. Let me just do my job, and we'll have a chance to talk later." That might be your best option. But there are challenging clients out there, and sometimes clients do make it harder to settle.
From the defense perspective, I agree with Josh. Really, it is a strategic consideration, and it'll depend a lot on the client and what you are trying to convey to in the case. For me, oftentimes I'm representing lawyers who can advocate effectively, and if I think a client is going to make a great witness, then I'll always discuss this in advance, typically with my clients to be ready. If their comfort level too. Sometimes clients will tell me, like, I don't want to, you're my lawyer, I don't want to be talking directly to the mediator, and I'll let that guide me. But where I think it'll be effective, or oftentimes too, my clients might be subject matter experts. If it's a particularly complex underlying litigation or legal practice area where they can speak effectively, that can be really useful. But there can be times when it might be to the client's overall detriment, if it is something emotional, or if credibility issues are going to become apparent. Those are things to consider and discuss, and guide how you want that interaction to go.
Mike, if you want my side of this, typically if I don't ask questions directly of the client, that's quite unusual. I want to talk to the client directly. It gives me a feel for how they will be as a witness, whether they contradict themselves over and over, or are just simply unable to accurately communicate their position. If I have the lawyer jump in and answer questions that I've addressed to the client, my first thought is, oh boy, that client's being hidden. There's a problem. I mean, it's just my first thought. And I'll often say, David, let me ask him. Let me ask him directly. And I'll get well, Peter, we've looked at this issue, and I'll think to myself, uh-oh, there's a client problem here. Now, maybe the other way. Josh, I may ask a question and he'll say, let me have the client address that, and this happens both on the defense and the plaintiff side. And I'll say, okay, great. And then I'll start a dialogue with the client, and I can get a feel for whether the client's being truthful or maybe a little avoidance is going on. I get a feel for how they are. I think all three of you have experienced, maybe unfortunately, my sort of soft cross-examination of a client. If there's an issue that I think is really detrimental, I may ask in very cross-examining type of terms questions of the client to see how they're going to respond. And typically, you know, at a break in the mediation, I may have a separate, private conversation with Josh or David and say, hey, if you think my cross-examination of your client was bad, wait till you get to court or wait till you get it to a deposition. I'm a pussycat compared to what the other lawyer is going to do to this client. And you've got to be prepared for that. And here's why, and here's the problem with it. And often it highlights issues that affect, whether or not the client's going to settle, that at least as to David's side of the cases, I often want to ask questions of the lawyer defendant in front of the carrier. So the carrier begins to understand the vulnerability that the lawyer might have, which in turns, purposely, I'm trying to loosen up the purse strings. And it's not just idle question asking. There's a purpose to it. So I'm actually probing. I'm trying to ask questions of the clients to find out information not only about them, but to convey information to them and maybe the carrier.
Great. All right. Well, we are out of time. And so I'm going to end our presentation. I want to thank our panelists, Peter Thompson, Josh Furman, David Samani. Thank you guys for a great presentation. Those of you who attended, please be on the lookout for more BHBA programming. The Ethics and Legal Malpractice Law section, we've got some CLEs coming up. Those of you that are members of the section, please feel free to reach out to me if there are CLE topics that you're interested in. We're happy to put together a panel that'll meet those needs. Thank you all for attending and have a great day.